going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Oh man, I've got a spicy one. This might be the spiciest I've ever seen this judge. She holds the attorney in contempt. It is, yeah, he lies to her. She calls him out on it. She's not happy. This whole case is just what is going on? I have nothing else to say. Watch it. That's all I got to tell you to do. All right, before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Expecting anyone else, correct?
Correct.
That is correct.
All right. Thank you. We will go on the record in the matter 21 CV 107 Carol J. Haskinson versus Ashley Head et al. Appearances are all by video conferencing capability or telephone conferencing by Zoom. We have appearing by at least video that I can see at this time would be attorney Joanne Wolf. I also have Abby Head by video. At this time, the rest appear by video conferencing capability or by telephone. We're set here today in this matter for a status conference. I'm going to turn.
Excuse me, Your Honor. Mulligan is on Zoom.
I can see that, and you're by video conferencing capability. I can hit the button to have you see if you can hit a button to appear by video. If not, that is fine. I'm seeing, yes, you are by video now.
There he is.
All right. So now I have both counsels by video, one client by video, the rest by capability. I'm going to turn to Ms. Wolf to provide the court with an update. We were here in July 25th, 2024, for the court to hear a reconsideration motion. The parties reached a stipulation. For the record, it was stated on the record and taken down on the record by both parties. It was cited by Mr. Mulligan, and then it was stated on the record and taken down by the court reporter and transcribed. It has not been brought to this court in a written form, at least at this time, even though the court has instructed the parties to do so. The court is going to turn to Ms. Wolf for an update. Ms. Wolf.
Thank you, Your Honor. Yes. As far as an update, I had sent a proposed stipulation to Mr. Mulligan on September 3rd, 2024. I have yet to receive a response to that stipulation. He did write a letter to the court in response to that stipulation. And the court then, Your Honor, responded and stated to Mr. Mulligan to order a transcript from the hearing. And I'm still waiting to receive that transcript. I have gotten some other communication from Mr. Mulligan stating that Ms. Hawkinson wanted to arrange to have a contractor to come out to the property. I requested on September 25th, 2024, for 3 available times that the contractor would be able to come onto the property. I have yet to receive a response to that. So at this point, Your Honor, we are waiting for information from Mr. Mulligan.
Mr. Mulligan, please provide me an update and let me know why I shouldn't just dismiss the matter with prejudice, which is my original decision in this matter, and leave it at that, because I'm going to tell you, I'm getting the runaround and it's frustrating the court. It's making a mockery of the judicial system. It's causing an extensive and substantial amount of financial legal responsibility, not only for your client, but for the Wolves as well. Why should the court not deny the motion for reconsideration and go back to it and have its original decision stand. Because again, July 25th, in which the court had all parties here to hear a motion for reconsideration. The parties were given an opportunity to sit down and to have time to reach a settlement, which they apparently did. The court was prepared to make a decision that day on whether or not to continue with the motion for reconsideration or to continue with its original decision, which was to dismiss the matter with prejudice. Mr. Mulligan, please entertain the court and give me some information.
Well, number one, Your Honor, the stipulation in order was not in conjunction.
Mr. Mulligan, 807.05 Wisconsin statutes. It was stated on the record, Wisconsin statute 807.05 makes it binding. And at that hearing, the court said, and I quote, it said, "Whoa," and were stated on the record, and it shall be so.
The record shows that we reserved our position once the opposing parties have ascertained any additional information. We reserved.
Mr. Mullen, I'm stopping you right now. I don't want you to reserve anything right now. I want you to tell me why I shouldn't go back and keep my original decision to dismiss, because we're still on this reconsideration. Dismiss with prejudice. That's where we were. And when we were here on July 25th, I gave the parties the opportunity to try and resolve the matter and stipulate to an agreement that could work for both of the parties, because I looked you in the eye, I looked your client in the eye, and both of you knew that your time to appeal had lapsed, that you had no longer an ability to appeal because there was no longer any time to appeal. Both you and Mr. Benson lost that by both other counsel. So I gave you an opportunity to reach an agreement in this matter. It was placed on the record. Tell me why. Tell me why I should not continue with my original decision to dismiss this matter with prejudice. Has this reached a decision? Am I to get the transcript, and am I to do an order based upon that agreement that was reached? Or is this matter dismissed with prejudice? Tell me now, Mr. Mulligan. I don't want to hear any this, that, or the other, and my client wants more money, my client wants this, and my client wants to agree to that. I do not want to hear that, Mr. Mulligan.
That was made a part of the record, Your Honor, and I think it's important for...
Mr. Mulligan, I want the basis of an agreement. Is there an agreement, and that the court can reach other, and the court, myself, me, the judge, can reach a decision on other issues, or is this matter dismissed with prejudice?
Well, it should not be dismissed.
All right. I'm really sorry for that. I'm having button problems over here. I've been having a battle with StreamYard all day. I don't know what's going on. It might be my fault. It might be their fault. Who knows? Yeah, judge is not happy. She's not. I don't really have to tell you what's going on. You can see it. I just had to give my obligatory pause. Let's go.
Dismissed with prejudice. We briefed that fully and would like a hearing.
No. July 25th, Mr. Mulligan, you had since July 25th. And prior to that, Mr. Mulligan, you had a whole lot of other time. Prior to that, August 9th. Prior to that, Mr. Mulligan, you had September 26, 2022. Prior to that, Mr. Mulligan, you had September 27th, 2022. Prior to that, Mr. Mulligan, April 4th, 2022. I am losing my patience here. Losing my patience.
To opposing counsel in August in an effort to get this matter.
One question, Mr. Mulligan, and you answer this question and you think very carefully. Mr. Mulligan. September 18th, 2024. September 18th, 2024. On your letter written to the court, which the court received on September 18th, 2024, in which you asked about language brought up in court and the contents. This court, myself, the judge, wrote, Mr. Mulligan, please order a transcript so that the parties and the court can see what was actually stated on the record for the agreement. We cannot rely upon minutes. Judge Mogan, September 18th, 2024. And I'm asking you, Mr. Mulligan, right now, think extremely careful about your answer. And it is a yes or no question. Yes or no. Did you order that transcript after September 18th, 2024? Yes or no?
I've got the transcript, but I don't have a recollection of Your Honor mailing me a response.
It was filed, Mr. Mulligan, this is an electronic file. So you received it electronically on September 18th, 2024. If you have the transcript, then why isn't it in the file? Because the court reporter files it once she does it. Who is the court reporter? Look at the transcript right now. Tell me who is a court reporter.
I don't have that information.
Get the transcript right now. Tell me who is a court reporter.
I can't because I don't have that information. I've got a copy.
I don't think you
of
ordered
what
it.
was transcribed.
I'm going to contact the court reporter and I'm going to ensure that you ordered the transcript as the court ordered. If you did not order the transcript, I am holding you in contempt and I'm ordering sanctions. Did you order that transcript, Mr. Mulligan?
I don't believe I did.
You just lied to the court. You literally just lied to the court. This matter is
No, I
dismissed
didn't.
with prejudice.
I don't lie.
This matter
to
is
them.
dismissed. This matter is dismissed with prejudice. You just lied to the court, Mr. Mulligan. This matter is dismissed, Ms. Wolf, with prejudice and with costs.
Thank you, Your Honor. Would you like us to submit an affidavit of attorney's fees?
Yes, I will. And whether or not you wish, the court is holding Mr. Mulligan in contempt for his failure to be truthful with the court right now. He just stated he ordered that transcript when the court told him to order that transcript.
But
And
wait a
you
minute.
just stated,
I
you literally
didn't
just
say
stated
I
on the record,
ordered the
Mr. Mulligan.
transcript.
You literally just
Did I
stated.
have a copy of the transcript? I did not lie to the court.
There, if you said you have a copy of the transcript, you can't have a copy unless you ordered it because no one ordered it.
I
And you
have
were
a
told to
copy
order
of
it. How do you have a copy of the transcript?
I don't have an answer for that, but I was thinking it was the clerk's notes.
No, you have minutes. And that's what I said. In your letter, you said, if you want me to read your letter verbatim, the plaintiff agreed only to the language that was brought up in court as to the contents of a concrete walkway. None of the rest was brought up to the court. Also, the remaining slab will have to be supported some other way. We will abide by what was announced in court, not what was added to the agreement, which is attached. We will follow the agreement as set forth in the agreement put on the transcript and not the extra verbiage, as it is beyond the scope of the agreement. Very truly yours, Thomas O. Mulligan. And you attached the minutes from the clerk. You did not attach the transcript. That is where this court, myself, wrote on your letter, Mr. Mulligan, my own handwriting wrote on your letter, and I quote, Mr. Mulligan, please order a transcript so the parties and the court can see what was actually stated on the record for the agreement. We cannot rely upon minutes. Judge Mogan, September 18th, 2024. That was filed in the electronic file the same day and time, extremely right immediately after I wrote it on your letter, September 18th, 2024. Then Ms. Wolf sent correspondence not only to me, but to you, Mr. Mulligan. Dear Judge Mogan, I am in receipt of letter dated September 17, 2024 to the court from Thomas Mulligan, attorney for Carol Haskinson. The letter also includes your response to Mr. Mulligan dated September 18th, 2024. It is my intent to respond to Mr. Mulligan's letter after Mr. Mulligan provides me with a copy of the transcript from the July 25th, 2024 hearing. Please let me know if you would prefer I respond at a different time or in a different manner. Respectfully submitted, Kelsey Law Office, PA Joanne Wolf. Ms. Wolf, did you then, after that letter was filed with the court, send a letter and have correspondence with Mr. Mulligan?
After sending that letter to the court, my assistant would have provided that to Mr. Mulligan, the letter. And then also there was communication with Mr. Mulligan on September 25th, 2024. I have an email from Mr. Mulligan to me with the name of a contractor. I believe it says, here's the information for the contractor, Construction Unlimited, W6430 Beaverbrook Avenue, Spooner, Wisconsin, 54801, and list the phone number. And then I responded to Mr. Mulligan on September 25th, 2024. And I said, please let me know of at least 3 afternoons, evenings. This contractor is available so I can arrange it with the heads. And I never received a response from Mr. Mulligan since September 25th, 2024.
And the court has not received any receipt of anyone ordering the transcript from the court's order of September 18th, 2024. And Mr. Mulligan, in my correspondence to you, I indicated to you minutes are not a transcript. They cannot be relied upon as a transcript. You provided the court with minutes. Minutes are different than a transcript. Minutes cannot be relied upon like a transcript. The court informed you of that. The court ordered you to order the transcript from the court reporter. You now just said that you did so, and then now you said you didn't, or you have a copy of it. You do not have a copy of the transcript. This has been a complete waste of the court's time. My decision to have the matter dismissed with prejudice stands. Please draft the order, Ms. Wolf, and send it to the court to sign. Thank you. We are.
Ooh, I did not want to interrupt that. I already did once because I'm having fun with buttons over here, just trying to figure out how things work. It wasn't interrupting the video. I hope you guys didn't mind too much. Anyways, that was yeah. Again, I've never seen Judge Mogan go off like that. I've seen her slightly upset and frustrated at times, but never angry. Yeah, I wonder what his sanctions are going to be. Held in contempt with sanctions. Probably going to be a fine. All right. I really hope you enjoyed this video. If you did, please hit that like button. That's all I got. You guys have a great rest of your day. Until next time, bye.